in law, there's this thing called res judicata. It's something you might hear knocked around in law TV shows or whatever, but it in a nutshell means that you can't go in and relitigate something over and over and over again. So if there's a court order that has been based upon, you know, certain evidence that was presented, or even a default judgment, something like that, the court can't go in and just redo it and redo it and redo it. There's very specific mechanisms where you can ask for a do-over, such as a reconsideration, a set-aside, a new trial, or an appeal. But aside from those very specific mechanisms that allow you to ask the court to review or reconsider a decision, you can't just go in and relitigate things. Now, in child custody cases, it's quite common for people to go back to court to ask to modify custody, sometimes multiple times throughout the child's minority. And we have very set procedures for doing that. It's a very common thing that happens in family court here in Las Vegas. But the thing you need to know is when and what you can bring up that happened before the last court order. So when you have a custody case and then you have a child custody order, and that order is in place, when you come back to court again, there might be things that you want to bring up that happened before that last custody order. Now, the default position is that you can't, right? It happened before the last custody order. It's said and done. Just bring up stuff that happened after the last order. But there's very specific situations where you can bring up things that happened prior to the last custody order. Now, if we're dealing with a situation where there was domestic violence or, you know, something that constitute a course of conduct, you might want to bring up the things that happened in the past to show that that conduct, that pattern is still continuing. And that, you know, while the stuff that's happened since the last order is like, you know, important but not huge, it's the same type of stuff they were doing before the last court order. And so they really need to know what happened before the last court order in order to have some context for what has happened since the court order. And that's if you're the one going in and asking for something from the court. Another situation is if you're defending. So let's say you have primary physical custody, you got it because the court found that there was domestic violence in your case, and now the other party is coming in trying to ask for joint or primary custody themselves. When you're defending that, you absolutely can bring up the things that happened prior to that last custody order when you're defending your right to custody that was based upon that, because you need to explain to the court. The court needs to know why they did that order in the first place. And so certainly that's a situation where you can bring up things that happened before the last custody order. And then another situation is if it wasn't known to the parties or it wasn't known to the court. So if you had a settlement that happened and there never was any evidence in the court record, the judge never knew any of it, then you can bring up those things that weren't ever considered in that decision, even things that happened before that decision.